elected not to do so.
But you could too, and your position was that you were standing on Caterpillar. I mean, Caterpillar does not answer this question clearly one way or another. So, I mean, that makes it seem like your choice was to take a wait-and-see approach and then decide whether you liked the result or not before you chose to fight it.
That's not correct, Your Honor. I do want to confirm the principal point that the court made. Caterpillar does not resolve this question, as the petitioners acknowledge in their reply brief, because it recognizes that if the jurisdictional defect remains uncured at final judgment, vacature is required.
It doesn't resolve. I mean, let's see, there are different ways to, but it
Correct.
doesn't resolve the question. So my point for this purposes of this question is solely that you're saying that you were standing on a case that doesn't squarely resolve the question, and that's why you didn't try to seek an interlocutory appeal?
Not, Your Honor, with respect to the preservation holding. Caterpillar does squarely resolve the question of preservation, that a party that raises the objection to jurisdiction has done all that is necessary to preserve the right to an ultimate appeal. Again, that's a party-neutral rule that flows from the final judgment rule. It's just the same principle that applies when a defendant objects to jurisdiction at the outset of the case. There's not an obligation to take an immediate appeal in order to vindicate that.
What do you think that...
I was just going to say, your question is, why didn't you appeal?
Right, but that, I mean, whatever. We'll just let that go. What is your answer to the questions about preclusion that Justice Jackson was asking you earlier? What would happen in state court? Do you think you would be, barred by non-mutual issue preclusion from relitigating some of these issues?
That is a controversial question. We certainly would not concede that preclusion would lie here. I would argue that there may be exceptions under state law, both because of the nature of the jurisdictional ruling in the first instance, and because there could be differences in sufficiency evaluation under state law as opposed to federal law. But all of that presupposes that the jurisdictional problem could be cured and that that judgment could actually have any substance on the merits, which I think is incorrect. I do want to speak directly to the court's question. The reason that there was not an immediate appeal taken was not only that the plaintiffs were relying on their right to seek review after final judgment, but as a practical matter in litigation, litigants make their best arguments, they preserve their positions, they respect the rulings, and they move forward. And our clients moved forward to litigate the case on the merits as best they could with respect for the district court's ruling.